Pettit, past president of the San Diego chapter. Very excited to have Ryan here from Pettit Kohn. Ryan is counsel for Dr. Bronner's as well as being at a firm that has been a great partner for the chapter. He's on speed dial and keeps us out of trouble. So very excited to hear even more tips on how to avoid employment litigation in 2026. Ryan is a shareholder at Pettit Kohn, an employment attorney responsible for representing California employers statewide in both counseling and comprehensive litigation support. So, with that, I'm going to hand it over to Ryan to take it away.
Great. Thank you so much, Dana. Thank you all for being here, for having me back. I was talking with Audrey as we were getting started. I can't remember how long it's been since my last ACC's presentation, probably a year or so, but time blends together. So wonderful to be back and to get to have a chance to speak with all of you. Since given the size of our group here, it's not too unwieldy. So if you have questions or anything like that, I will keep an eye on the chat. And then also, in fact, I'm going to open that up, which I think people have access to, and feel free to ask questions. It doesn't have to be me talking at you for an hour. I want this to be as interactive as you'd like it to be, and I want to make sure that we go down the appropriate rabbit holes here. So without further ado, I'm just changing my screen a little bit. Excuse me. Okay. I will gloss over my bio and start by saying, okay, we're going to avoid employment litigation 2026. The most important thing you all need to do is follow the law. Right? Let that hang heavy in the air for a moment. That's table stakes in all of this. What today is not going to be is a recitation of, employment law update 2026. At this point, at this stage in the year, you've all probably been to several of those. You get the mailers from our firm, from others. You've been to other presentations. So what I'm not going to do is read to you all the new laws and the nuance of what the new things say and how to work around the margins. What I'm going to talk about today is how lawsuits are really happening. And I can tell you they're happening a lot, right? We are monumentally busy because lawsuits are getting filed. And they're getting filed very often not for the reasons that you'd expect. So again, yes, we're going to follow the law, but we're not going to talk as much about that. I want to start by talking about why lawsuits typically happen. And I want to talk about what the expectation is. Now, obviously, given this group, it's predominantly attorneys or attorney adjacent, right? Given the nature of the organization. And so I'm preaching to the choir a little bit, but I don't think that much. And I think it's helpful. Years ago, I did a speaking series called Happy People Don't Sue, which was, just a pithy title. But the idea was, what do you do to keep your employees away from the lawyers? And what do you do to keep them from coming after you and trying to find the way to take your time, your money, your effort, your aggravation? And I think the expectation and reality are very different. And this is relatively basic, but it's also happens over and over, right? We think that what we have is we have a happy employee, right? And everything's all well and good. And then something happens and the employee goes, aha, my employer broke the law. They did something wrong, and now I need to find a way to punish them for it. So they're mad about that. So what do? That's when, after they read all these books that are really just a Zoom background for me, they say, this is the law that's been broken, and they go to the lawyer, and then the lawyer invokes the scales of justice, right? That's the general concept that we think it follows. It is not at all the concept it actually follows. What happens is the employee gets pissed off for any number of reasons, right? They get irritated, they get frustrated, they don't get the promotion that they covet, they don't get the office assignment, they get a schedule that's different. Something happens, their boss is mean to them, their colleagues are mean to them. Something happens where they get irritated. And then what do? They don't go to the law books, they don't look up on AI or whatever, did this my employer break the law? They go to the lawyer first. And when they go to the lawyer, they say, hey, something happened at work and I don't like it. My boss was mean to me. I didn't get the office I wanted, whatever it is. And the lawyer says, well, that's not illegal. But while you're here, why don't we go through these law books? And then all of a sudden, those lawyers have a list of questions, right? And they'll say, okay, let's talk about your employment. Did anyone ever make a comment to you about your race or your gender? Did someone who's a different race or gender or sexual orientation get that office that you coveted, get that promotion that you wanted, get the better schedule? Did you always get your meal breaks on time? Or, hey, I see that you typically got your meal breaks late, and it's probably because you wanted that, but did you really want something else, right? We see that in restaurants a lot. And then all of a sudden, that lawyer goes through the checklist. And when they walk out of that meeting, they're ready to invoke the scales of justice because they have found the claim. The person didn't come to them with the claim. They figured out what it was going to be. And by the time that person gets to the point where they're sitting in deposition across the table from me or from another defense counsel, they believe in their heart of hearts that they've been wronged in the way that is violative of the law, and they're going to come after you for it. So what's the goal? When they're upset, A, don't make them upset, but keep them away from the lawyer and keep them away from those scales of justice, right? Very, very basic, but it is absolutely without a doubt the most important concept as we're dealing with this litigation or the prospect of litigation. So I'm going to go through, and by the way, the slides, they're not very heavy slides because they're more concepts and more conversational concepts. But I believe ACC already has them. They can distribute them. And if you need them directly from me, by all means, reach out. And on that token as well, if you have questions that you want to ask me outside the context of a chat for whatever specific reasons, back in the day, we could do that in the hallway. We don't do that as much anymore. So by all means, reach out to me. My contact information is on the end. I want to help you. I want to talk through that nuance. I want to make sure you're getting the guidance there. So as we're looking at all of this, the first part is how you make them feel. And that sounds silly, right? There's a story I've told many times, and I've retired it from these because at this point, it's been heard and told so many times. So I'm going to give the very, very high level version of a case that I was involved in, or my firm was involved in years ago, where ultimately, and again, very high level, company did something that was objectively fine. They needed to make an employment decision against someone who'd been with the company for 30 years. She was a wonderful employee. They loved her. They respected her. But it turns out that she just wasn't doing the job at the level they needed once she got all the way up on the hierarchy, right? It was the Peter principle, if you're familiar with that, right? She just wasn't cutting it there. And the company had to make a decision. And they made that decision. And it was an okay and justifiable decision. And by the way, the law protects our right to make the wrong decision, right? Business judgment is an important factor in what we do. And there's a jury instruction. If you take these cases to trial, the jury will hear that you're not asked to determine whether or not the decision was the right one from an empirical business sense. You're only being asked to determine if it was the right one from a legal sense. Was someone mistreated in some legal way? And this case went all the way to trial. And in fact, there was a motion to dismiss the case. And everyone said, oh, no, the judge rather said, no, you know what, let's just let the jury handle this. But what the jury heard is that when this person was let go, it was handled very poorly. The day that she was let go, she was let go over a Moons Over Miami at a Denny's restaurant to start. When she got back to the office, not only was her replacement sitting in her office, but all of her stuff was sitting outside of it. Not illegal, mind you. But what the jury looked at is the way that made this employee feel, and very importantly, asked one important question. They wanted the employer to ask, what can we do to help you? And they didn't. And when given the opportunity, the jury punished that employer. Now, again, that's the very high level version because I promised myself I'd retire it, but it's exactly right for this presentation. The point is, and you've got the Maya Angelou quote that we've always heard from this, people think about how you make them feel. So as we're doing this, and as we're looking at how we can maintain morale, that happens in a lot of different stages. And very often, for those of us in this virtual room, we're not necessarily the people who are driving decisions. If we're sitting on, on the GC side of things or outside counsel, or we're advising, we're not the ones who are necessarily carrying things out, but we can help drive the way that things happen, right? And so that happens in lots of different ways. Employees make mistakes, right? We know this. This is a fact of life that we're going to have employees that do things that aren't right. I'm not saying you give them a second chance absolutely every time that happens. What I'm saying is you need to work with your managers to figure out whoever it is that's communicating it to make sure you understand what the dynamic is. Because very often when something comes and hits my desk, it's by virtue of that conversation not going the right way. So when you think about it, you want to think about it not in terms of did we break the law? Because with very limited exception, you didn't break the law, right? Companies don't wake up in the morning saying, you know what, we're going to fire all the women out of our office today. Of course they don't, right? That doesn't happen. I hope that doesn't happen. But lawsuits happen all the time. And juries return big verdicts, unfortunately, kind of a lot. And the issue is that juries aren't looking as much at what is legally happening. They're looking at the story and they're thinking about what their version of fairness is. We say this all the time when we go to mediation or we're trying to settle cases, or I have to tell a client, hey, I think you need to resolve this case. And they say, well, we didn't do anything wrong. I said, yeah, but you need to look at it through the eyes of, can you convince, you walk into the office today, you walk past 12 people on the street, say you're downtown or whatever. Can you convince all 12 people who come in with their own experiences, their own opinions, their own feelings about their bosses that wronged them or the time that they got screwed out of the office or the promotion? Can you convince them that you did everything right and you were fair? You got to look at it that way, and you got to make your decisions based on it. Doesn't mean that we're going to give everyone a second chance and a fifth chance and a 20th chance. It means we need to think about, did we do it the right way from a morale standpoint? The best way that I think about it, and candidly, there are people on this call that I work with, right? And when we talk through, well, you're letting someone go, or you're counseling someone, you never want it to be a surprise. Because when it's a surprise, that's when they make the call. And there are umpteen million different law firms out there that are happy to take that call and happy to have no more conversation than you're angry, we'll figure something out. So let's try to keep them away from them. One of my partners here loves to talk about the New York Times rule. And I think that's it's a pithy and nice way to think about it. Fortunately, most of the time when you all are on the other side of a lawsuit, the New York Times isn't picking it up, right? It's not something that is newsworthy enough. However, think about your decisions in the New York Times rule manner, which is to say, how would you feel about this story being told on the front page of the New York Times? If you can own it, if you can feel like you did everything that was possible and appropriate under the circumstances, then you're putting yourself in the right position. There are always going to be people who want to be a stickler or who want to say, you know what, I don't care, it's not fair, I got screwed. So be it, that exists. But I cannot possibly tell you, and again, it sounds basic, I can't tell you how many times litigation that I see, especially these days, starts from someone that feels like they were wronged in a way that wasn't legally significant, but it was emotionally so. Do what you can to keep yourself out of it. That's the softest part of all this. So if you're thinking he's not going to talk about law, I will, I promise it's coming up. But you got to start and end with that. Think about how you're making people feel. Okay. Now let's get a little bit more into the detail of law. Now, I'm not going to, as I said, sit here with a recitation of what meal and rest breaks need to say and what time tracking needs to say and that sort of thing, because you know that, right? That's table stakes. But what I can tell you is I see lawsuits all the time and I see little problems. So let's talk about what some of those are. We are seeing a glut of wage and hour, either class or PAGA litigation. Now, I'm probably preaching to the choir a little bit on what those are, given the dynamic here, but just to make sure we're all reading from the same sheet of music. Class action is what we typically think of as a representative action, right? One person could file a lawsuit and their lawyer seeks to represent a full class of employees. They're seeking actual damages that are alleged to have been caused against those employees. And it goes back a period of 4 years going back from the date of filing of that complaint and continues onward until resolution, whenever that may be, whether it's settlement, typically, or theoretically trial. PAGA, there are a lot of ways you could think about it, but you can kind of think about it as class action light. PAGA is the Private Attorneys General Act of 2004, which, as the name suggests, has been in place for just over 20 years now. And it seeks penalties on a per employee per pay period basis. And it goes back a period of 1 year back from the date of a filing of a complaint. And again, looks at these penalties on a per employee per pay period basis. So it's not what is the value of the meal premium that was allegedly owed. It's, did something happen in that pay period that gives rise to the penalty? Now, we could spend a whole hour or more on PAGA. I'm not going to do that, but suffice to say that PAGA has seen a lot of attention lately. And in fact, about, I want to say it was a year and a half ago, it may have been 2.5 years, but I think it was a year and a half. We got what we're now referring to as new PAGA. So PAGA was reworked, and in a generally good way. It created opportunities for organizations to cure potential issues that are being alerted, right? If you've done something wrong, you can cure those to try to get yourself out of harm's way. It also sets different floors, or actually, pardon me, it sets ceilings for recovery, depending on what types of policies you have in place, what types of trainings you have. We'll talk about those in a minute, but what has happened, or what the thought was with PAGA, is that by revising PAGA and changing the processes, we were going to see a downtick in PAGA litigation. That's not been what's happened. In fact, it's gone the other way. We're seeing more and more PAGA cases, and the attorney. We talk to the attorneys on the other side. It's very recidivist. We see the same faces pretty frequently, and they're saying, you know what, we're still getting the same results or close enough results, so we're still doing it. So, what can you do as an employer? Take a look at those policies, right? I can't tell you how often I get a new case and it comes in, and one of the first things that I ask for is your handbook, right? What does it say? And I can't tell you how many times it happens that I get that handbook and at the bottom of it says revised in 2009 or 2012, 2015. A lot of years have passed since then. Don't do that. Put yourself in a position, it's spring, do a little bit of spring cleaning. It's better to do it at the beginning of the year, quite frankly. You do something in January. I think that's preferred, not vitally necessary, depending on the changes that you need. Companies that are regularly updating, it's fine, but make sure that you're taking a look at that. Because there are little nuanced changes to the law that we see. And I can tell you from experience that if there is a nuanced issue, plaintiff's counsel is going to capitalize it. On top of that, don't change the policies, right? Don't change the ones that your lawyers, right? When you have a law firm, whether it's my law firm or one of the many other wonderful law firms in this town, and they say, here's what you need to have in your policy, don't get cute, right? Don't say, we're going to change this. We're going to do, our employees don't like that, so we're going to do it. Once you have something that is on its face improper, you're going to have a bad time. Don't do that. And I see that all the time. And very infrequently is it done with malice. More often it's done as, hey, we're just trying to make this more aligned with what we do, what our employees do. We're trying to give them opportunities to excel or succeed or be happier. Yeah, but understand that can and is weaponized against us. I can give you some examples, right? I had a case not too long ago that we ended up getting a very good result because we were able to really buttress our position and explain why we did it this way. But it could be sticky, right? So it's a manufacturing company, that food trucks came to their business twice a day, right? And I'm going to mess up the time a little bit, but like everyone started somewhere around 6 o'clock in the morning, just about, and the food trucks came at 10 o'clock and 2 o'clock. That timing might be a little off, but you get the idea. And so what all the employees chose to do is they say, okay, we're going to call it a meal period, although they auto-deducted, and that's a separate issue we'll talk about. We're going to take that meal period first, and then we're going to go to the food trucks there, and we like that, and that's great. And then when the food trucks come back later, we're going to squeeze our 2 rest breaks together, and we're going to take those and basically take a 30. So they weren't even taking 2 10-minute breaks, they're taking 2 15-minute breaks combined to make a 30. So that way we can enjoy a second longer break on the clock. Well, on its face, that's a big problem, right? Because we saw the records, and what happens in these cases, we get a copy of all the records and we look at them in plain black and white, meaning without any explanation as to what actually happened. And if you look at records on a case like that, you're going to see extraordinarily high rates of potential violations. Because if you're not tracking or you're allowing people to basically take these meal periods late in a way that it looks like every single day, just about every single employee has a violation. When you go to try to settle that case and explain your way around it, you're going to have a rough go because you need to explain why it looks on its face like it's a problem. So I want you to think about that. There are lots of different industries covered by the folks in this room, I'm sure. I understand that there's nuance to your workforce. I understand that your employees have desires of what they want to do from a scheduling standpoint. But the best thing that you can do is be as transparent as possible in having the right policies and then making sure that you're communicating the diversions from them as appropriate. Now, it's not to say, the law requires that meal periods be taken before the end of the 5th hour of work. And anytime it's above that, we're going to see a potential violation. There can be explanations for that, but we're going to see them. In a perfect world, you have them all clean and you don't have to worry. Exceptions can exist, but let's be smart about it. The example that I very often give is my legal assistant, who's wonderful, takes a lunch that's late every single day because that's when she goes to pick her daughters up from school. It's great. That's what she wants to do. It's perfect. She gets time with them. Everybody's happy. But we've made it very clear that she understands that, and it's a one-off, and she understands that she's not entitled to a premium when she chooses to do that. The problem is if you fall into that warm bed as an employer and you say, okay, well, we're just going to let everybody do whatever they want. And we're not going to look at it. We're not going to audit it. We're not going to figure out what's going on. And then when somebody comes back to us and says, I didn't get that to which I was entitled, you don't have an explanation. So what I want you to do is understand what your employees need and want, but look at it through the prism of the law. As you're doing that, understand that paying, from my standpoint, no, I'm not looking at this from a business standpoint because you don't want to be spending extra money. I understand that. Paying premiums, meal period premiums, and rest period premiums is a great thing. That may sound strange, but one of the first things that we look at when we have class litigation or any type of representative litigation, we get all the data and we have a team that does it all and they put it on. They're wonderful and they give me this giant spreadsheet. And literally the first thing the first thing I look at is the rate of meal period potential violations. The second thing is I scroll over like 70 lines and I look for the number of premiums that are paid because I want to see those premiums paid. That feels odd because what you're hearing potentially is, well, if we're paying premiums, that means we did something wrong. No, it doesn't. It means you did something right. When there are times where someone cannot receive their meal period in the manner or rest period in the manner that they're entitled under the law, which happens, they get paid. And so that creates a positive inference for you as an employer to say, okay, when it's owed, we pay it. So when it's not paid, we didn't owe. Great, great, great argument to have. Now, you're going to have employees that take advantage. It will happen, right? There are going to be people who see, okay, well, I have this opportunity now that when I can get an extra an hour of pay at my regular rate of pay every single day if I just take a late lunch and I'll just get paid on it. It's counseling opportunity. You can meet with those folks and you can say, hey, we see that you're getting paid a lot of premiums. What's going on? Is that you thing or is that nuts thing? And I've had clients that say to me that they talk to the person, they say, yeah, I just want the money. Okay, well, counsel. No, we're going to pay it when it's owed, but you need to be better about your time. And it allows us to paint a better picture. Along the same lines, and actually, by the way, on the premium thing, there's a case that actually really well supports this. And I think, if I'm remembering correctly, I think the defendant was Safeway, but don't quote me on that. But there was a rather, not scathing, but direct opinion that was issued by the judge on this, which basically said, look, if you don't pay meal period premiums, one of two things is possible. Either you are the employer that has achieved nirvana in the way that you provide your employees meal breaks, and you've never had a violation ever. Or, far more likely, you're doing it wrong. And that inference is a bad one. So put yourself in that position. Along the same lines, we want to make sure, this is more on the meal and rest period thing, because that's what we're seeing, it's where the biggest hits are in dollars, typically, is be accurate in your records, right? There was a time where it was okay to just have everyone report and say they work from 8 to 5 every day and they write down when they take their meal period. Don't do that. We have technology. We have biometric scans where you can have people do it. Make sure you have a system in place. Invest in that system to make sure that you're accurate. You can be accurate to the second, so do it. Because if you don't, and people are reporting, it's so easy for plaintiff's counsel to say, hey, it's all round numbers that can't possibly be right. So there has to be an issue. By the same token, what we're seeing a lot of now is we're seeing plaintiff counsel that looks kind of with an eye towards if it looks too perfect, even on those schemes. If everyone is always clocking in exactly on time, they're taking their meal periods exactly on time, and they're exactly 30 minutes long, that they're saying, well, that can't be right. Now, I have my feelings about that. These people are adults and they can clock in when they need to, and your policy is they got to clock in. Great. But just be aware of it. What I want you to be doing, this is among the takeaways, is look at your policies and look at your practices through the eye of that plaintiff's attorney that wants to put his or her hand in your pocket, right? Because you're going to have people that are going to pick apart everything. And if it looks too perfect, the inference isn't going to be, oh, you're great and you've achieved that level of nirvana. It's going to be, it's too perfect to possibly be true. So don't do that. Along the same lines, we're seeing a lot more claims of de minimis, what we used to call de minimis violations, right? Where it's, oh, it's a minute here, it's a minute there, it doesn't really matter. It does. There was a case that came out now a handful of years ago where Starbucks got hit. Well, in the decision, I don't know exactly how it shook out. I'm sure it's settled. But what the court said is, these Starbucks employees, I think it was like hourly managers, if I recall correctly, that had to do a few things right after they clocked out. So they clock out for the day. And then they got to lock up the doors. There's a requirement that they walk certain employees out to their cars to make sure they get home safe. And the court said that's compensable time. So while that may not apply to all of your industries, there are a lot of different ways that could. If you're in a warehouse setting and people need to walk around, or if you have a campus where it's complicated, err on the side of finding ways to compensate your people, right? Because if you don't do that, you're gonna create that argument, and the best way is to avoid it. And then beyond that, it's just all the general policies, right? When you have things that are specific to your industry, which are going to exist everywhere, write something. Just because it's not kind of the quote normal thing that goes in everybody's handbook. If you have something that says this is what we do, right? We're a campus, and so people will travel around the campus, or we have unique travel off the work site policies, or we're I arbitrated a case I don't know, a year or two ago where it was an organization that had a number of locations, and we spent a lot of time fighting, and ultimately, fortunately, prevailed. But fighting about the regular commute for that employee, because that employee traveled to one location most of the time, and it was her home location. But then when she went to the other ones, we were able to successfully argue that they were closer, and so we didn't have to compensate. But we needed to look at that, and you could imagine a scenario that's just ever so slightly different where that would have been a rather large problem. So for us as employment counsel, we can help you draft things. Obviously, that's what we do, but we want you to take a critical look at the policies that you have and the policies that you may need that are unique to your particular line of work. I want you to also work with your manager, right? Because it's one thing for all of us as the lawyers to kind of sit in our ivory tower and make these beautiful, clean, crisp policies that have everything we need. And then we don't empower or train or entrust, not even entrust. We don't allow our people or give them the tools to appropriately follow through on that. And many times, probably most times, litigation arises because middle managers just don't know better, right? They don't mean ill of things, but they don't quite understand. And that can happen in lots of different contexts. It can happen from a policy standpoint, and we'll talk about leave in a little bit and things like that and following that out. Very often that falls on an HR department if it exists for your company, or for legal for that matter. But it can also be on softer touch things, right? You've got employers or managers that don't quite understand the dynamic. Bullying is something that, for a handful of folks in this room, I've done harassment training for. And when I do harassment prevention training, one of the things that I'm required by law to talk about is bullying. Bullying on its own is not illegal, right? Because technically, with a very large asterisk, mind you, don't just write down bullying is not illegal, we can do it. I don't mean it like that at all. What I mean is just being a jerk to somebody is not an actionable item. That's interpersonal. However, bullying is such a close cousin to harassment, which is actionable. Now, because harassment needs to be based upon a protected characteristic. Now, in California, we've got, I don't even know the exact numbers, 20 different protected characteristics at this point. And those have tentacles that go out in just about everything. So everyone has many different protected characteristics. And if an employee, whether it's a supervisor, whether it's a colleague, whether it's a subordinate, whatever, is making comments that don't feel right for the workplace, it's usually not that hard for a creative plaintiff's attorney to say, well, you know what? I think it's because of gender, because of sexual orientation, because of race, because of whatever. So help your people understand. That go, and again, we can spend lots of time thinking of all the examples where conduct can be harassment adjacent. We just need our folks to understand. And that comes in harassment prevention training that you need to have them do every 2 years. Sure, everyone is doing that, and that's great. But it's other touches, right? When you see something, say something. And that doesn't mean that, you need to be walking around as kind of the police state saying, hey, I saw you tell a joke. And so now we're going to, but it's making sure people understand what's appropriate and what is not appropriate in the workplace, because all too often, those are the things that bubble up, right? That's the conversation that, go back to my slides from the beginning. The employee goes in and they say, my boss is a jerk. And the plaintiff's attorney has to say that's not illegal, and then they got them, right? So avoid that at all costs. Well, actually, I should take that back. Not avoid it at all costs, but work with your people to help them understand what appropriate workplace decorum is. It sounds so simple, right? When I do presentations like this, I always have this moment or moments during the course where I go, This is basic. Everyone's going to be rolling their eyes at me. Don't, please. I beg you, don't, because I see litigation every day. I'm going to get an email while I'm in here about a new loss. That's how this goes. And so often it starts with this, and it's so basic, and it mushrooms into something so much bigger. Please, 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 please help yourselves. Okay. Let's talk about record keeping. Uh, if you've been involved in litigation, as I'm sure many or most, if not all of you have, the typical first shot across your bow when a case comes in is that you'll get a request for a personnel file and payroll records. So that can come in many different forms. And any employee, whether current or former, is permitted to ask for a copy of their personnel file and payroll records at any time. And payroll records must be provided within 21 days, personnel file within 30 days. That is an absolute right. Oddly enough, the same arbitration that I was talking about from earlier, we won on absolutely everything other than my client, far before I got involved, did not send the personnel file when they were supposed to. Now, in the grand scheme of things, it was $1,500 of a penalty and a little bit of attorney's fees, and not a huge thing. Everyone was still happy, but it could have been a zero. And that's because you see this and you go, this is ridiculous. This guy doesn't have anything. And if he sees his file, then he's going to try to make something. Maybe, but you have to do it. And importantly, on the back, or I guess the front end of that, you need to keep those records, because there are a lot. Not only are you obligated to produce what you need, but in the instance of litigation, with some exception, depending on the type of the claim, burden of proof is on us, right? That's a little bit of an overstatement, but we as the employer hold the cards. That's the nature of claims that we have. Plaintiffs, the evidence that a plaintiff has in your normal piece of litigation is typically the claims that they're making, right? The allegations that they have, which are things that they're going to say. And then their damages, right? Did they find replacement work? Did they mitigate their damages? Did they seek medical treatment for emotional distress? That sort of thing. That's basically it. We have everything else. We have all the records that go to their personnel file. We have all the records that relate to their time and their pay. We have all the emails where we're counseling people and we're working with them and we're telling them that we need to, they need to be better. If we can't find, or we delete, or we never have those records, that puts us even farther behind. And the way I think of it, employment cases, if it's a 100-yard dash on any case, we're starting 20 yards behind, always. If you don't have the records, we're starting even farther behind than that. Now, that can exist in the context of spoliation of evidence, like you're actively bleeding things. That's a whole different animal. Please don't do that. But it also just exists, and so you didn't keep it, routine deletion. Don't. Right? The cost of saving documents, of making sure that you maintain your records, is so much less than the cost of not having them and needing to be able to use them, or having to cobble something together with them. So please do that. On the topic of record keeping as well, there is a phrase that I hate, which is paper the file. Right? I'll get calls from clients. We'll say, okay, well, we've got this bad employee. We just want to paper the file and fire him. I don't like that. Because all too often it's transparent, right? Now, I want you to keep good records. So going back to what I talked about at the onset, if you're counseling someone and you're helping them improve, or you're placing them on a performance improvement plan, you need to keep a record of that. And I want that to exist, because it's not helpful when you tell me, well, we talked to him 50 times last year, but we didn't write it down once. No. What I'm saying is, if you're creating paper for the sake of paper to try to buttress a claim or a defense to a claim down the road, you're already a step behind. Make it more organic. Don't make it so it looks like you're setting someone up. Along those lines, when we talk about counseling people, I hate the idea of, if the company's already made a decision about something and saying, oh, well, we're going to put them on a performance improvement plan, and then we'll fire them at the end of that. If those words come out of your mouth in that order and in that short a time period, I need you to rethink that. Because the idea of a performance improvement plan is in the title. It's an opportunity for someone to improve. And so if you're going to put them on that plan, I need you to be able to say that we are intending to help make you better, and that there is a light at the end of that tunnel. Now, mind you can put someone on a PIP and then it doesn't work out and you let them go. That's fine. But I need it to be a good faith effort, because it's brutal when I'm sitting in a deposition and, we'll prep you, right? We'll make sure that you understand what's going on. But when the honest line of questioning is, well, you put him on that PIP, right? Yeah. And at that point, you already knew you were going to fire him. Yeah. So why'd you give it to him? I don't know. What can you say? That's a difficult place to find yourself as an employer. So I want you to be more straightforward. If you made the decision as an employer that we have to do this, we are going to let someone go, let's certainly talk about it. But you got to do it. You got to do it, right? It doesn't always benefit you to take more time. And we'll talk about leave in a little bit. That can complicate things as well. But I want you to be deliberate in everything that you do. And going back to the management side of things, I want you to train and trust and empower your managers to do the same thing. Because while they may think that they're doing the company a favor, they may think they're doing the employee a favor. It needs to be with the right amount of forethought, because if it isn't, you can find yourself in a little bit of trouble. Arbitration agreements are always a thing that we want to talk about. It's an ever-changing area of the law. There haven't been a ton of huge sweeping changes in the last few years, with some exception. But the bigger issues, let's talk about arbitration agreements and why, if you don't have one in place, I want you to at least consider. Now, it's not always the right decision, because there are certainly cons that are on here. But to me, the pros almost always outweigh the cons. So in an arbitration agreement, what you can do is you can, very importantly, you can agree that someone will waive their right to pursue a jury trial and instead will maintain something in or pursue their claim in arbitration. There's benefit to that, right? An arbitrator is far more likely to see through the surplusage, kind of the flotsam and jetsam that is around a case, and focus on the law, focus on the facts, not how that makes you feel, but whether or not the law is actually broken. That's a good thing. Typically, especially, obviously, we're ACC San Diego, but if your organizations have work in Los Angeles County Superior Court is a terrible place for defendants. It just is. They call it the bank, because it's where plaintiffs go to get paid, right? You don't want to be. And so if you can avoid that, generally that's what you want to do. Now, you have to bear the expense of that. So, well, let me talk about that in a second. You can also include in there class action waivers. You can't waive PAGA. There are a few different cases that briefly you could, but then we knew it was going to happen. You can't anymore. But you can agree to submit the individual PAGA claims to arbitration, which is a helpful proposition for you as a defendant. And then there are a few different procedural things you can do from that. I won't get too much into the weeds there, but it's valuable in the class action waiver sense. Because if you get that class action complaint, if the first thing I can do is go to plaintiff's counsel and say, hey, got an arbitration agreement, class claims, they may fight us on that, but assuming it says what it's supposed to say, courts will enforce those agreements. So that's valuable. On the downside, it's expensive. The costs to an employer, or pardon me, the costs unique to arbitration must be borne by the employer. What that means is, as it says, you as the employer must pay for the arbitrator. And arbitrators are really expensive. These days, upwards of $100,000 for an arbitrator is the norm. Even if it's a 5-day hearing, that's what you're going to get. So that means you're going to get bled a little bit on that side. So you need to be aware of that. We have some of the more well-heeled plaintiffs firms. If they're faced with a class action waiver, what they'll do is they'll say, okay, sure, I'm going to find 10 more plaintiffs. We'll commence 10 arbitrations, and we'll make you pay 10 arbitration fees. Okay, that can be a little complicated. So I want you to think about all of those things, but I'm telling you that aggregating all of this from where I sit, which is, a step removed, and I'm on defending these things, it is almost always better to have an arbitration agreement in place than it is to not have it. So at the very least, think about it. And then, by the way, I guess one quick additional or two. Most of the cases that we've seen recently deal with a bit of an oversimplification, but two main topics. One is the language in the arbitration agreements, and two is the timing of payment on the arbitration agreement or on arbitration invoices. So payment of arbitration invoices must be paid within 30 days of when they're due, or you as the employer lose your right to arbitrate. So when you get that bill and your lawyer says to you, here you go, here's an invoice for the 10 grand to get this started, or the 100 grand for the arbitrator's fees, you must pay that like your hair is on fire. Because if you do not, you run the very real risk that it's going to get kicked back to Superior Court. You're going to lose the right to arbitrate. You're going to get sanctioned for it. You're going to have a problem. Don't do that. One. The other side is the language thing. Without going too far into it, what courts look at are procedural and substantive unconscionability in signing the arbitration. Procedural is the process, right? How did this person receive and sign the? Did they receive it? Did they have time to ask questions? Did they understand it? Was it in the language that they speak? That sort of thing. So you want to give them an opportunity to do that. My pretty strong preference, I realize this isn't possible for everyone. I prefer for there to be wet signatures on arbitration agreements. I think that's far easier to compel, because we're seeing a lot of arguments where people say, hey, that's not my client's signature on an electronic signature. It's harder to do that with a wet signature. I realize that may not work for all of you, but it's something to consider. And then there's substantive unconscionability. What's in an agreement? What language do we have? Very often what we'll have is some lawyer, me or some other lawyer, will send you an agreement and say, here you go. Here's what needs to be in this agreement. And then the employer will get a little cute. And not meaning to do this, but they are. They'll say, okay, well, I see the part where it says that the employer must bear all costs unique to arbitration. Nah, we're going to make it split. It's a contract. We're going to have them split. No, can't do that. We're going to limit the number of claims or the types of claims that can be made. No, can't do that. We're going to unnecessarily limit discovery or different. No, you can't do that. So don't try to create a leverage proposition against your employees when you're giving this to them, because at the end of the day, if you have an arbitration agreement, you want to be able to enforce it. So help put yourself in the position to do it. Okay. All right. I want to talk a little bit about reasonable accommodations and leaves of absence, because again, these are not complicated things, but routinely and regularly we see them turn into issues, right? We've all seen this before where, well, a couple of different iterations of, you've got an employee who comes in and they're going to get placed on a PIP, and you put them on a PIP and the next day they go on a stress leave. And you're going, oh boy, well, why don't we just fire them? Well, if you fire me, against you. That's why. You need to work with your employees to try to counsel them appropriately. It doesn't mean that if they go out on that stress leave that you can't address the PIP when they return, but you need to honor that opportunity, right? Because if you don't do that and you swiftly swing the sword, let's get a tongue twister, you're going to make that person desperate, and they're far more likely to do something rather than working backwards from things. Say, okay, thank you. Let us know when you're able to return, or depending on the circumstances, if they say, we'll come back, whatever it is, allow them to take their leave, work backwards from yes, and then you can address what needs addressing in the back. I'll tell you candidly, very often people go out on leave, especially if they know that when they get back, they're going to have a hard conversation about their employment. They just go away and they find another job. And when that happens, you're out, right? Because now, instead of you trying to be the one to drop the hammer and say, oh, we're going to fire you. Or I'm sure you've all seen, or many of you have seen this before. Someone goes out on leave and you realize they weren't doing their job in the first place. Oh, you see all the cracks that are shown. Well, if they come back and the next day you fire them right away, don't love the optics of that, right? Let's work through these things. Let's make sure that we give people an opportunity to succeed. Because if you do something that creates a negative optic, you're going to put yourself in a far more difficult position than if you handle it more appropriately. Ultimately, the accommodation process or the interactive process is exactly that. It's a two-way street. It's interactive, meaning that you need to have conversations with employees and they need to have conversations with you. So if you have an employee that says to you, hey, the only thing that I can do is sit on a gold-plated throne at work every day because my doctor says it, well, that's probably not doable. Or, you're in a manufacturing setting and they say, well, I can't lift anything. And the only position you have is a CEO job. Well, that probably isn't fitting for that person at what they were doing with stock and shelves before that. But have a conversation, because ultimately the analysis in all of this is undue hardship, right? Is it an undue hardship on a company to not arrive at that reasonable accommodation? And all too often, what I see are employers that just immediately jump to that and say, oh, no, undue hardship, let go of them, go away. When that happens, you're just putting yourself in a position where if you work backwards from yes, you're going to keep them away, more likely to keep them away from the lawyer, and more likely to be able to avoid that headache and that heartache in the first place. This all dovetails with leaves of absence. Pardon me. So, we all know as a general concept that we have in California, the CFRA, the FMLA, is the federal construct that provides what we call job protected leave. Table stakes, right? Everyone knows that. But what happens too often is I have people say, well, hey, I put them out in their 12 weeks of CFRA and then they couldn't come back to be fired. No. It can still be a reasonable accommodation through the ADA to provide an extended job protected or to provide an extended leave that may or may not be job protected in the amount of time. But if you have someone, God forbid you've got someone with a serious illness or it's badly hurt, they got a family member for whom they're providing care, whatever the case may be, and they come to you at the end of their 12 weeks and they say, hey, I just need a little more time. How does it hurt you as an employer to say yes? Right? You've made it this far without them. You've survived. They need another week. They need another 2 weeks. Is that really going to hurt you that much? Now, I understand it's a double-edged sword, right? Because the more you extend, the more it looks like, well, you can do without them. So then now you've had them out for 3 months or 4 months or 5 months. What's another month? What's another month? What's another month? Yes, I get that. I know that that's wildly frustrating. But there is no bright line rule for any of this, right? We can't say, okay, you get to a year, that's enough, that's what the law says. That doesn't exist. And so on all of these things, I want you to continue to be working backwards from yes. If you ever find yourself or you find your managers in a position saying, gotcha, right? I got you. You exhausted your leave. Now we're going to fire you. You've done it wrong. Right. You need to be able to continue to engage in the interactive process and to evaluate potential accommodations, which can include additional leave as necessary. And again, bear in mind what I said earlier, which is that very often you can't, very often they'll go away, right? And that'll be it. Okay, so this is a good question. And so what if they go MIA, right? So thank you for asking that question in the chat. At a certain point, I like to put the ball in there, right? Let's say I'm gonna make up an example that hopefully tracks with where the question is going, right? You've got someone and they go out for 3 months and then their doctor keeps coming back with another note and the doctor keeps extending it another month, another month, another month. And then at some point you just don't hear from them. So it's April right now and last you heard from them is January. What do you do? At that point, I think you can change tack ever so slightly in the communications that you have with them. You put the ball more in their court. And you say something very nicely, which says, hey, we haven't heard from you. We assume that you're still out on leave. Let us know if and when you're able to return and we can discuss opportunities. Now, what you're doing there is you're not committing overly to anything because it may or may not be possible for you to return them to the same or similar position, but you're also not poking them in the eye. You're not saying, hey, you're fired. Because if you drop that hammer, that's when people do things, right? That's when they do things a little more desperate. Another suggestion as that happens, very often insurance can be the tail that wags the dog, right? Someone's out on leave, you're paying for their medical insurance. You can make your medical insurance broker be kind of the bad cop in this and say, hey, make sure it's truthful. But if your insurance company says, hey, we can't keep someone on active medical as an active employee if they've been out for X amount of time, 6 months, 9 months, whatever it is. Well, there's your opportunity to reach out to the employee and say, hi, hope you're doing well. Just so you know, our policy or the medical insurance policy is that once you've been out for this amount of time, we have to COBRA you out. I mean, you'll say it more articulately than that, but they have to go out on COBRA, which, as we know, COBRA is expensive. Very often that spurs things along in one of two ways. Either the employee who, if it's someone who's kind of a milk and disability, and now all of a sudden is seeing the prospect of having to pay a steeper bill for their medical insurance through COBRA, might say, okay, maybe I'm feeling well enough to come back to work. Or if it's been long enough and really they haven't been wanting to come back in the first place, they go and they find another job. And once they find that other job and you've not poked them in the eye by firing them, you just said what you have to say to them, you're giving yourself a better out. But all too often, when you drop the hammer and you let someone go, and that's the impetus for action, right? It makes them scared. It makes them nervous about their future, their financial prospects, whatever the case may be. And now that's when they go and they start thinking about what their options may be. One of their options, quite frankly, is to see if a lawyer is going to take it. And if they want to find a lawyer, they'll find a lawyer, right? So let's keep them away. But that's a great question. I'm glad you asked that so I can talk. You got to be flexible with your folks. We have policies. We have policies for a reason, right? We need to, and policies generally need to exist in black and white, right? But there can be exceptions. I am a very big proponent of dealing with what's in front of you versus the hypothetical down the road impact, right? If someone has a question, someone wants to do something, someone has a strange set of circumstances where they need to work remotely in a different way than most of your employees do, but you can make it work as an employer. Do the same thing we're talking about with leave. Work backwards from yes. Can you do it? Because what's going to happen, the question that I'll get is, well, if we do this for this person, what's going to happen when the next 10 people ask? I don't know. Let's deal with it when it happens. Because, I look at this at the macro level. Very often, there aren't as many recidivist, repeat, copycat claims as you might see or might expect to see. You might just deal with it one time. So deal with it one time in the way that's best for that employee. And for your business, right? It doesn't mean you have to say yes to everything, but it means you can have diversions from what your typical practice is, as long as it's legal, as long as it's generally consistent with your policies and how you act on things. But if there's something that you can do and it's a reasonable request, consider it, right? Because ultimately, doing that can save you a lot of headache and heartache on the back end. So just try not to be too strictly adherent to any of this stuff, okay? Again, follow your policy. Don't mishear me. Don't follow your policies. You have policies for a reason, but just understand that every single situation is nuanced in some way. And so the more that you're able to consider that and understand that and appreciate that, better. Last bullet point like this, or last slide like this before we go into the big picture concept is, avoid the little mistakes that can become big ones. There are a lot of issues that can arise that feel very financially or operationally minor. For example, reimbursements, right? If you've got an employee that's traveling, from one building to another, that's a mile down the road, and you can say, well, do we need to pay him for that? Yeah, you do, because you're supposed to. Now you can figure out the right way to do that, but you're figuring out a way to handle it. Because what you don't want to do is when the lawyer comes in with that checklist and has to get to the bottom of the list because they can't find anything else, and they go, oh, aha, you had to bring in your tools, you had to do this, you had to use your cell phone, right? I can't tell you how many times we have people that, let's be honest, all of our employees are talking on cell phones with one, right? And sure, your argument can be, well, we have ways that everyone can communicate in a different manner. But if you know darn well that all of your employees are using their cell phones to communicate for work-related purposes, reimburse them. Come up with something. Say it's $10 a month. I don't care, but I don't really care how much it is. I care that you have it. Because it's a far better argument for me to be able to make to say, hey, they did it. And they put a line on the bottom that said, if this isn't right, tell us and we'll fix it. Then they didn't do it at all. And we have to argue that they didn't need to use that or use their tools or get reimbursed for mileage or do whatever. It's a trite classic saying, but an ounce of prevention is absolutely worth a pound of cure in these types of cases. Same thing goes for final paychecks, right? If we know that the law tells us that if we let someone go, you need to give them the final paycheck within 24 hours. If they quit without advance notice, we have 72 hours within which to provide it. Okay, well, sometimes what can happen is you don't have time to cut the check, right? You let someone go on a Friday, and the person that processes the payroll or whatever it is can't cut a manual check on Friday. So you say, we'll just do it on Monday. Well, that's not consistent with the law. So make it easy on yourself. Pay him until Monday. That's okay. But same thing, ounce of prevention, pound of cure. If you go ahead and do that, and you say, okay, your last day of work is going to be today, whatever day, Friday, but we're going to pay you through Monday, and that's going to be, we process it. Now you've gone out of your way to do something that very likely is a pretty small financial event for the company, but it's done a whole lot to ensure that you're staying out of harm's way in the back end. Commission agreements, we could spend a whole lot of time on this, but I think it's worth mentioning. I see all kinds of commission agreements, and very often when I get them, I don't know what they say, right? I'm working through it, and I got to call the client and say, I don't help me understand what you're trying to do here. Now, sometimes that's because it's an industry specific thing, and so it may well be that where I'm sitting, I'm just not close enough to the business to understand that these phrases do mean something and everyone understands it. That may be, but ultimately, the onus is on us as an employer to make sure that commission agreements are written and they're clear. Because any ambiguity is absolutely going to be construed in favor of the employee. So make sure it's clear, make sure it's in writing, make sure it lays out how you're going to be compensating your people. Because ultimately, if it's not, you're going to be the one that bears that risk. And it's going to be a heck of a lot more time consuming, expensive, frustrating to fight it on the back end. And then finally, the gotcha conversation is the one I want to avoid, right? Where you're talking to your employee and it feels like you're springing something. You're saying, you're out of leave, you're fired, or you didn't know you weren't acting poorly, or you were performing poorly, but we're firing you. If things feel like we're springing them on our employees and they genuinely don't understand what's happening, or they're surprised by it and they should be surprised by it, you haven't done a good job of communicating it to them. So make sure that you're having those conversations with folks so that way things aren't a surprise. If it's one thing, and this goes to my next slide and last slide, we don't want to be an ostrich, and that's what we'll talk about. But I don't want, if your employees are burying their head in the sand, they should know better and they don't. That's a whole different conversation. But I don't want you to be in that situation. So, it's easy to ignore. And this is kind of the closing thought. So I'll wrap this up. And if you have questions, by the way, ask, and I can stick around however long you'd like. But it's easy to ignore. And sure, we're on this group, we're mostly, if not all, lawyers. And so our job is to look closely at these things. But it's also really easy to, and that happens all the time, where, we don't want to change the policies. We don't want to come up with something. We don't want to enact something. We don't want to have the meeting where we talk about it. We don't want to have that kind of thing. That makes it a lot harder for us to put it back together on the back end. So I think the best thing that you all can do is be forward looking in your planning, look at what you have, perform your audits, do your trainings. We talked about PAGA earlier and I didn't go too far into it, but from PAGA prevention standpoint, you can help set those ceilings by having trainings with your employees about how to ensure that policies are appropriately followed through. When you do things like that, you make better defenses for yourself in hopes that you never have to use them. And that is the hope, of course. You want to be the company that never has to deal with this. Unfortunately, from a purely statistical standpoint, if you are an employer in the state of California, something is going to happen. And the best thing that you can do is put yourself in the best possible position. And I say that, again, go back to that first slide. Yeah, follow the law. I didn't talk to you much about the law today because it's not why. It's not the soft. It's the new one. So give yourself that opportunity to stay out of harm's way on the front end. And if you do that, you're going to save yourself all of that hurt in the back end. All right. I've got 2 minutes left, but I've got all the time in the world. So I don't want to keep anyone, but if anyone has any questions, whether verbally or in the chat box. I'm okay. No, I don't think I missed any questions. So if I did, ask them another way, but any questions? Anything I can do?
Brian, Diana had to jump, so she asked me to just close this out, and I'll stick around for a couple minutes with you for questions to moderate. But just wanted to thank you. Very practical, excellent content. Thank all of you who joined us today. Please do take the moment to fill out the survey when you get that, because that helps us provide you with great content, including bringing someone back. So please do that. And then, if there are questions, go ahead and put them in the chat, and Brian and I will look to make sure they get answered for you.
Thanks so much. And if you have questions directly, obviously feel free to reach out. I don't need to put anyone on blast with their specific issues, but if you have something, by all means.